بسم الله الرحمن الرحيم الحمد لله رب العالمين قيوم السماوات. We have, by the grace of Allah subhanahu wa ta'ala, reached the section on khiyarat. And this is an important lesson. And this is an important lesson because we have something in our times that resembles the option of cancellation, which is the refund policy. The refund policy is something that resembles. Okay, just give me 1 second. بسم الله الرحمن الرحيم الحمد لله رب العالمين وصلى الله على سيدنا محمد وعلى آله وصحبه وسلم. Alhamdulillah, in our lessons on Multaqa al-Abhur, we have reached the lesson on khiyarat, the option of cancellation. And the option of cancellation to a modern is more specific. And that's one of the things that don't just say, okay, well, the option of cancellation is like the refund policy, because there's some resemblance, but this is different. And we'll see how as we approach this. So today we're going to understand what is khiyaru shart, its duration, and understand some of the underlying disagreement related to it. We'll also distinguish what happens to ownership, Hanifa, and we'll explain why that is the case. Okay. So Imam Ibrahim al-Halabi rahimahullah ta'ala says, Babul Khiyarat. Here there is an interesting discussion that you can find in Majma' al-Anhur, and for those of you who are serious students, they describe that there are 4 types of ilal. Ilal. Right? Right? 4 types of effective causes. Right? And he breaks it down in terms of how they apply to khiyar al-shart. There are 3, that's one discussion, right? And we won't go into that, but right? And we won't go into that, but I'm just pointing towards it. Shart, the option of cancellation. The second is khiyar al-ru'ya, the option of inspection. The second. The third is khiyar al-aib, the option of cancellation due to defect. So these are 3 fundamental khiyarat, but there are many secondary ones, some of which we will see under, in the discussion here, incidentally, they are listed in the 2 commentaries, if you would like to see them. Okay. Now the khiyar, yes. Go ahead. Okay. Is this any better, Sadati? But it's good enough because your voice is interrupted. Okay, تماما. نسأل الله العافية. بسم الله. Okay, so there are many types of khiyarat. Now, a khiyar basically is an option, right? That if found, the one who has it has the right to end the contract. The khiyar al-shart, the khiyar is على خلاف القياس. The qiyas, the primary line of legal reasoning would be that neither party has the right to cancel. As an initial assumption. Why? Why, Sadati? Yeah, because the contract that has been finished, so once the contract is complete, the ijab and qabul are complete, what happens? Yeah. Yeah, so there's tamalluk and tamlik, right? There's an exchange of ownership. And then the principle that we understand, of the many principles that we understand from the verse of trade through mutual agreement is that لا يجوز التصرف في ملك الغير من غير رضاه, right? That it's not permitted to do anything with another's property without their permission. So if you cancel the contract, you're acting without their permission, without their rida. So this is a mafsada shar'iyya, right? This is a mafsada shar'iyya. That's the default. But this, we see that there is a need. If it's specified, right, the khiyar al-shart, the option to cancel, if it's specified, we can understand aqlan why it would make sense, correct? There's a haja lit-tarawi. There's a need to think a transaction through, but the khiyar al-shart, the option of cancellation, has to be specified. That's why in Arabic it's called khiyar al-shart, right? The specified option to cancel. So يثبت بالاشتراط. That's number one. خيار الرؤية is affirmed because of the texts related to it. And the texts related to it, we'll come to it, are most strongly a number of athar from the Prophet ﷺ's companions. There's some mursal hadiths, but coming together, the meaning is sound and it's confirmed by a sunnah mutawaratha that if someone buys something that they haven't seen, they would have the option to cancel it once they see it. And the meaning underlying the khiyar ru'ya is that if you buy something but you haven't seen it, are you really satisfied with it? In terms of the item of sale, I sold you the sibha, I described it, but you haven't seen it. You can't tell its feel, its quality, etc. So we understand why we would leave the initial qiyas, which is no. Without specification, you can't cancel a contract. So that's khiyar ru'ya. The third main khiyar is the khiyar al-aib. And the khiyar al-aib, again, we leave the initial legal reasoning, which would be, the qiyas al-awwal, which would be that, could be that, well, you can't cancel a contract after it's made, but we would say that the aib is something that affects two things. One is that a transaction presumes soundness, right? Any transaction presumes soundness. And number two, the aib, the defect, what does it lift? It lifts rida. It lifts being satisfied with the transaction. So on both counts, it affects the validity. It affects the properness of the contract. We'll see what's the status. So if there's a aib, this loss of rida is dealt with by having the option to cancel. By having the option to cancel. So these are the three principal khiyarat. There's others that will be coming up. So let's see what the author has to say. Rahmatullahi ta'ala alayhi. قال الإمام إبراهيم الحلبي رحمه الله تعالى صح خيار الشرط لكل من العاقدين. It is valid to stipulate the option of cancellation if stipulated, right? A shart, right? For both the transacting parties. أو ولهما معا, right? For each one of them or for both of them together. ثلاثة أيام, for 3 days, meaning, and no more than 3 days, right? So 3 days or less, but not more. لا أكثر, لا أكثر, not more than that, according to Imam Abu Hanifa, إلا إن أجاز في الثلاثة, unless more than that was stipulated. So they stipulated that it's for 4 days, but the one who had the option exercised it either to cancel or to make the sale binding before the 3. By doing so, the fasad is lifted before it's set in. Okay. So the option of cancellation for either party or both. And the Imam said it is only for 3 days. Why only for 3 days? Because this khiyar is established لحاجة التروي. So you can think things through. And is it موافق للأصل or خلاف الأصل? According to Abu Hanifa. Is the khiyar shart, does a sale entail that there be the option of cancelling it after the fact? No, right? Sadati, let's stay with me, please. Okay? So it does not entail having the option to cancel. So it's على خلاف الأصل. What we see بالرواية, so the معقول would be that it's for the haja of tarawi, of thinking things through. And you only need a little bit of time for that. But the ahadith specify 3 days. The ahadith related to khiyar al-shart specify 3 days. So Abu Hanifa said, okay, that's the limit that would be taken. And Abu Hanifa adopted caution when it came to any exceptions to the bindingness of the contract, as we took. And this is the transmitted fatwa position of the madhab. The transmitted fatwa position of the transmitted mu'tamad of the madhab is the position of the Imam. How do we see that indicated in Multaqa al-Abhur? Yeah, because he mentioned it first. And he mentions the position that is the mu'tamad of the madhab first when he mentions the khilaf. Okay. But we will see, right, next that وعندهما أي عند صاحبين يجوز إن بين مدة معلومة أية مدة كانت. أي طالت أم قصرت. So according to the Sahibain, it is valid in the option of cancellation to stipulate any time period, i.e., even more than 3 days, whether that time period be long or it be short. And why would they say that? Because the reason is للحاجة للتروي. So there is an exception that is established, and that who makes taqdeer of their haja? صاحب الحاجة. I may need more time. But then Abu Hanifa would argue, but it could lead to dispute. But the response would be تعارف الناس اشتراط أكثر من 3 أيام. That people establish the urf of agreeing to more than 3 days. So, so here the transmitted position of the madhab generally, as we see here too, has been the position of Imam Abu Hanifa, because this wasn't a widespread urf to take their position. But then the Majalla, when it came to address this, they saw a lot of people were dealing contrary to this. So we've shared here item number 300 of the Majalla. And this section from the Sharh of Shaykh Khalid al-Atasi, basically, what does it say there? يجوز أن يشترط الخيار بفسخ أن يجوز أن يشترط الخيار بفسخ البيع أو إجازته. Right? مدة معلومة. It is valid to specify the option of cancellation of cancelling the contract for any known time period. So this is اختيار من المجلة لقول الصاحبين. Why? Yeah, because of the urf, right? Because of the urf related to that. And this urf did not lead to dispute if it's stipulated, right? It's stipulated. So the Imam Abu Hanifa concern was deemed not to apply. And that's what, and you can read this section from, inshallah, we should see, Abdul Latif, remind me, we will, you can see it in the slides, but we'll share this discussion from Shaykh Khalid al-Atasi's commentary on the Majalla. It is of great benefit. But the option to cancel could be for the seller or the buyer. Sidigu Khan's passing by Toronto, he purchased my sibha, but I said, I want 2 days of the option to cancel. Why? Because I think that maybe my son wanted the sibha. So he takes it, but I might want it back. I wanted to make this sale, but maybe not. So I wanted the time to think it through. But you can see what the issue would be, that if we stipulated 10 days, 20 days, how would you feel if I sold you the sibha? I said, I have 1 month to cancel my sale of the sibha to you. It would be way too hard to send it back. Cargo would be more expensive. So, right, it could. But when would traders stipulate it? When they felt it was reasonable, right? So the option of cancellation is basically the option to decide whether you want to complete the transaction from your side as the seller. In my case, I sold Sidigu Khan this sibha for $100. And I said, but I have the option to cancel, according to Abu Hanifa, for 2 days, 3 days. And there's consequences in terms of ownership. And does it now become yours or not? Which we will see in a moment. It comes up in the text. We try to diagram it for you as well. But according to the Majalla position, it could be more than that. But similarly, the option of cancellation is limited. If you purchase it, Sidigu Khan, what is the option? During that period, the option of cancellation is for you just to decide, do I want to keep it or not? So you can test it, but if you start using it, does the option remain?
Would that be considered imba al-aqd, so it's over?
Yes. So because the option of cancellation is basically for you to decide whether you want to keep this item, right? Like as a buyer, or you want the sale to be completed or not. So you can test the item as a buyer, but كل ما يدل على الرضا فهو إمضاء. Any action that indicates being satisfied with the item, such as using it, would be considered um, completion. This is different from a refund policy, because a refund policy is a contractual stipulation. Does the refund policy typically, does the seller ever have a refund policy that, okay, we may take the item back for 3 days? No. Typically, the refund policy is only for the buyer, the mushtari, number one. Number two, the refund policy could be of different types. It could be no questions asked. That doesn't matter how the item is. If you want to return it, return it. Right? And that is considered a shart muta'araf. Right? It is a contractual stipulation that people customarily make. So that goes under shurut. The basis is that we shouldn't be stipulating too many of these things, but people do transact in this way, so it has been allowed. Right? So there's a difference between, this is, the refund policy, right, is different. That's a contractual stipulation, not entailed by the contract, because in many cases, like there's a 15-day return policy. If Sigu Khan has been using the Sipha for 10 days, but it's in good condition, using most refund policies, of course, they differ according to what they. Could he return it after 10 days using a refund policy?
Yes.
Yes. Um, so these are araf, but generally, if someone is able to adhere to virtue in a transaction, but to simplify transactions, it is better. Okay, let's go back to the text. He says, rahimahullah ta'ala, regarding khiyar al-naqd, because this is similar. وإن اشترى على أنه إن لم ينقض الثمن إلى 3 أيام فلا بيع صح. If one purchases an item, ala, meaning on condition that if he does not make the payment within 3 days, i.e., or less, there is no transaction, this is valid. But someone could really like something, say, look, give me 3 days to pay for it. And he tries to gather the money to make it. If I'm not able to get the money, I don't want to be stuck with it. We don't want to fall into dispute. So this is allowed. This is called khiyarun naqd. And this is istihsan. The basis is no. A sale is binding, but they left this because of the need and because people transacted in this manner, and the shara allowed it. It did not lead to dispute. Rather, it probably wards off dispute. وَإِلَى أَرْبَعَةٍ لَا. But for 4 days, it's not permitted. And then, إِلَّا أَنْ يَنْقُضَ فِي الثَّلَاثَةِ, unless one makes a payment within 3. So it would be sort of pending fasad, but if you rectify it before, it would be valid. وعند محمد يجوز إلى 4 وأكثر. And according to Imam Muhammad and Abu Yusuf on this position, it appears that he is with the Imam. Right? That according to Imam Muhammad, you could specify it for more than 3 days. And again, If the urf is on the position of Imam Muhammad ibn al-Hasan, there would be leeway to consider it. The khiyar al-naqd, the option of cancellation if the payment is not made. But Abu Hanifa's position remains safer on this as well. Okay, so that's khiyar al-naqd, that if the payment is not made, the contract would be annulled. It can be stipulated for 3 days according to the Imam. If more, it's invalid unless the option is exercised within the 3 days. The position of Imam Muhammad permits it for more than 3 days if specified. Then what happens to ownership? So the option, the khiyar shart could, the possessor, the ba'i' could have it or the mushtari could have it. And just conceptualize, I sell this sibha for $100 to Sidi Gukhan on condition that I have the option of cancellation. Now, if I have the option of cancellation, who owns the sibha during this period of time? So we will look at this, right? We will look at this, right? He says, وخيار البائع يمنع خروج المبيع عن ملكه. If the seller has the option of cancellation, then the item of sale does not leave their ownership. Right? Because I want to be able to cancel it, I can cancel it because it remains mine. Right? So it makes the cancellation easier conceptually. So it's an amana, right? It's akin to an amana in his hand, in the buyer's hand. But it's amana plus, as we will see in a moment. So he says, فَإِنْ قَبَضَهُ الْمُشْتَرِي فَهَلَكَ. So if the buyer takes possession of the item of sale and it perishes in the hands of the buyer, the mushtari, لَزِمَتْهُ قِيمَتُهُ. He has to pay its market value. He does not have to pay what? The thaman. What is the thaman? Yeah, the thaman is the agreed upon price. It could be more than the market value or it could be less. That's the thaman. The qima is the market value, which is what the market deems this item to be. And this is, inshallah, Sayyid Abdul Latif, remind me, we'll share something on what's called al-maqbood ala sawm al-shira. Right? So this issue, right? If I just lent this sibha to Sidi Gukhan because he's thinking of buying it, what is its classification right now? If Sidi Gukhan has it and he had it in his pocket and someone stole it, does he have to compensate me for the sibha? No, right? So it's an amana. And if an amana perishes in the hands of the one who has someone else's amana, what is the ruling?
He's responsible for what happened and he's responsible for what happened.
Yeah. So the amana, there's no daman, right? There's no compensation for the loss of an amana unless it's due to the negligence of the one who had the amana, which is two ways. Ta'addin aw taqsir. Right? Either if he did the harm himself, so Sayyid Gukhan decided to test how strong the sibha was by biting on the string. and he was standing in front of a drain, and all the sibhas fell through the drain. That's ta'addin. Is it reasonable use to bite on the string of a sibha? No, that's ta'addin. Taqseer is negligence, where he left it on the table of an Istanbul cafe and someone stole it. Here, however, a sale took place, but with the option. So the hand of the buyer, when there's an option, when the option belongs to the seller, the hand here is a heavier hand than simply borrowing something. So there's an issue which arises from transactions, which is that when people buy and sell, if that if people are the what's called somu shira, right? Somu shira is when you are negotiating to buy something, and the sign of it is you're told the price, right? So see Gukhan saying, well, he's thinking of buying things from Rabbani books. He says, how much is this sibha? Right? So says, are you interested in buying? Yes. So he takes, and I tell him the price, right? So there's interest in buying, and I tell him the price. Then if, he slips and falls and the sibha is destroyed for some reason, the qima is due. This is the called somu shira. This is very useful in a store if you have things up for display, right? So it's very clear. All these items are there for display, and the price is listed. Then, if you break something, the market value is due, which is whatever you agree to pay for it. It might be the listed price, or if they differ, then they'd either agree on what the market value is, or they have to bring someone to agree on the market value. So that's som shira, right? Som shira is when something is being considered for sale and the price has been mentioned. There, what's som shira? When something is being considered for purchase and the price is mentioned. Two conditions. What is due? Like if it perishes, it's madmoon. The market value is. But if something, you're just looking at something, this is called somun nazar. You're just looking. So there's sibhas hanging outside someone's store. I walk by. I didn't do anything. It fluttered, or let's say it hit my shoulder, but I'm just walking naturally, just hanging from the store. It touched my shoulder because the wind blew and it fell in down the gutter. Was that up for sale? Were we? That's called somun nazar. I was just looking, how is this sibha kook, and I'm looking at it and it breaks. If I'm just looking at it, called somun nazar. So we've not really gone into its active consideration for purchase. It perishes, it's amana. Right? So let's say if we pick up the sibha, it said, tell me about this sibha. And someone shoves me and it falls down the drain. That's just som another, correct? Because there isn't an active consideration for purchase, right? So it's not somu shira, it's just nazar. I'm just looking at it. But when it goes from just looking at it to consideration of purchase and the price being mentioned, then it becomes madmoon. And this is to prevent harm in transactions, right? That if you're deeply considering something, be careful. You be more careful with it. So we'll share some resources on this som shira and som nazar. You can find the text related to it. So when the seller has the option of cancellation, the mabir is the qima is due in it. The qima is due in it. And if the buyer has the option of cancellation, وخيار المشتري لا يمنع. Right? وخيار المشتري لا يمنع ماذا؟ لا يمنع خروج المبيع من ملك البائع. So if Sidi Gokhan, in the Sibha example, if Sidi Gokhan has the option of cancellation, right? Do I have the option of canceling it?
No.
No. So it leaves my property. Hmm? But the price doesn't leave his ownership. He has the option of canceling. So there's a payment for it. I have to safeguard. He gives me this ancient leather pouch that is as valuable as the Sibha. It is not an ancient leather pouch, but it is a leather pouch. I don't know what to do with it. But so this doesn't enter my property. Okay. فإن هلك في يده. Right? فإن هلك أي المبيع. So if the item of sale perishes in his hand, in the hand of the mushtari, the buyer. لزم الثمن. Right? Then the full price is due. وكذا لو تعيب. And likewise, if it became blemished. إلا أنه لا يدخل في ملك المشتري خلافا لهما. But إلا أنه, however, in this case, the item of sale does not enter into the buyer's possession. It sort of remains suspended because this transaction hasn't been completed according to Imam Abu Hanifa. خلافا لهما, contrary to the position of the Sahibain. And some of the ulama said the fatwa is on their position on this, right? So practically, if there's an option, we can break it down as following. If the option is for the seller, what happens? It stays in their ownership. Right? What stays in their ownership? The item of sale. If the option is for the buyer, what happens? It leaves the seller's ownership. But according to the Imam, it doesn't enter. So it leaves the seller's ownership. According to Imam Abu Hanifa, it doesn't enter the buyer's ownership. And according to the Sahibain, it does enter the buyer's ownership. And the Thamarat al-Khilaf is in the issues that he now mentions. And these are issues that mostly don't arise in our times. So we're not going to spend a lot of time. But if you understand this, this diagram that we just saw, right? Right? The option of the seller has the option, the item stays in his ownership. If the buyer has it, it leaves their ownership. And according to the Imam, it doesn't enter the buyer's ownership. Keep that in mind as we look at these issues. The fa here is the fa of tafriya. Right? فلو اشترى زوجته بالخيار. If he buys his wife with the option of canceling the sale, what happens here? Right? How could someone buy their wife? So, can you buy a free human being?
No.
So, what would the scenario be? Hmm?
You married a slave.
Yes, someone married a slave. Now, the other item to know, can you be married to a slave that you own yourself? No, right? Because so if someone's wife enters into their ownership, what would happen to the nikah?
Yes, sir.
The nikah would be annulled. But in this scenario, لو اشترى زوجته بالخيار, if he buys, if the seller buys his wife with the option of cancellation, لا يفسد النكاح, the nikah is not immediately annulled. Why? Because she does not enter his ownership. وإن وطئها فله ردها. So he has intercourse with her, he has the option of returning her. لأنه بالنكاح, because it is through marriage. إلا في البكر, unless it is in um, with respect to the virgin, because that would be then considered عيب, right? ولو ولدت في مدته لا تصير ولده. And if she gives birth during this period, she does not become his walad, right, during the time of the khiyar. Because it's conceivable that she, the actual, she got pregnant earlier. Um, so she would not become walad because she did not enter his ownership. Uh, and then, can you own your own relative? Same thing applies, right? That ولو اشترى قريبه ولو اشترى قريبه به أي بالخيار, right? So an immediate mahram. أو عبدا بعد قوله إن ملكت عبدا فهو حر. Or if he purchases a slave, saying that if I ever own a slave, he is free. And he purchased it with the khiyar الشرط, then لا يعتقان في مدته. They're not considered free during the time period of the khiyar. Why? Because while he has the khiyar, do they enter into his property? When the mushtari has the khiyar, does it enter into his property? No, right? So it so that's the principle, right? You cannot own your immediate relative, so they would be freed. But only when they enter into your property, if you have the khiyar, it does not, they do not enter your property. ولا يعد حيض المشترى به في مدته من الاستبراء. Right? And the hayd of the one purchased with the khiyar al-shart is not considered from the period of istibra, because istibra begins from when the person has property of the amma. ولا استبراء على البائع, and the ba'i' does not need to, in this case, that if the in raddaha, if the ولا استبراء على البائع, there is no istibra, right, which is the period of waiting before intercourse. If someone else, if someone else owned the, the amma, is not due on the ba'i' in ruddat ay bil khiyar. If the amma is returned with the khiyar. Why? Because it didn't enter the mushtari's ownership. And if it didn't enter the mushtari's ownership, intercourse would not be permitted, correct? Because if intercourse took place, if the buyer did engage in intercourse, what happens to the khiyar? What happens? It's gone, right? So these are theoretical. We don't need to go into a lot of detail. Theoretical in our times. ولو قبض المشتري به المبيع. If the buyer takes possession of the item of sale, the مبيع به أي بماذا؟ With the option of cancellation, with the permission of the seller, the بائع, بإذن البائع. ثم أودعه عنده, and then left it in the safekeeping of عنده أي عند من؟ يعني ثم أودعه أي أودع المشتري المبيع عنده أي عند من؟ عند البائع. And then he gave it in safekeeping to the seller. فهلك, and it was destroyed. فهو على البائع. Right? Right? So it is that is upon the seller. لارتفاع القبض بالرد, because the taking of possession is lifted by returning it to the seller. لعدم الملك, because he did not own it yet. Who did not own it yet? The buyer did not own it yet. Again, if you want to conceive of these issues, make an example, break it down, and you'll see why. Right? There are other consequences as well. ولو اشترى المأذون شيئا به. If the مأذون, the slave who has the right of transaction, buys something with it, i.e. بالخيار, فأبرأه بائعه. So the seller absolved him عن ثمنه, of the ثمن, of the price due. يبقى الخيار, يبقى خياره, his خيار remains. وله الرد, and he could return it. Right? على عدم التملك, because no taking of possession happened. Right? Because just to say you don't have to pay it, because he may not want to keep the thing anyways. ولو اشترى ذمي من ذمي خمرا به فأسلم في مدته بطل شراؤه كي لا يتملكها مسلما. And if, right, if a dhimmi, if a non-Muslim purchases wine from another dhimmi, non-Muslim, bihi, with the khiyar. So the purchasing non-Muslim, so let's say Butrus purchased wine from Michael with the option of cancellation. But Butrus became Muslim, became Basil. So when he had the option to cancel, did the wine enter into Basil's ownership? No, he didn't already own it. So فأسلم في مدته, and he became Muslim in that time period. بطل شراؤه. This contract is annulled, lest he come to own something haram in a state of Islam. Because just as he could not, can you acquire wine as a Muslim? No. The transaction itself would be haram. You cannot acquire wine as a Muslim. The transaction is haram. The transfer of ownership does not take place. So here, the transaction was older, but the ownership did not transfer, so you cannot acquire it. So the only way that would happen would be that sale would be considered annulled. If you already owned it from before, he would have to dispose of it. This is according to Imam Abu Hanifa. And خلافا لهما في الجميع, contrary to them in all of these matters. And the fatwa is on the position of the Imam as the asl of the madhab in these matters. We don't want to go into a lot of detail as to how and why. Now, ومن له الخيار يجيز بحضرة صاحبه وغيبته. The one who has the option to cancel can accept the transaction in the presence of the other party or in their absence. ولا يفسد ولا يفسخ إلا بحضرته. But you cannot cancel except with the knowledge of the other party. خلافا لأبي يوسف. And what's meant by بحضرته أي بعلمه. It doesn't have to be so, and you cannot cancel the contract except by telling the other person. Right? So if you want to continue the contract, you don't have to say anything. Right? So in the case that Sigu Khan purchased the sibha from me for $100 on condition that he has the khiyar shart because he wanted to test how the home front would deem the purchase, but it seems smooth sailing. On day 3, does he have to say, I'm keeping it? Yeah, it's automatic. But you cannot cancel it without telling me, because then I'd want the thing back, etc. Yeah, so but key thing is, bihadratihi means with his knowledge. With his knowledge. Right? Because otherwise it would harm the other party. Because if you cancel it, now they have haqq al-tasarruf. They can deal with it. Khilafan li Abu Yusuf, because Abu Yusuf said that you can cancel it even without telling the other party. And there's fiqh related to his position. Right? فإن فسخ وعلم به في المدة انفسخ. So if he cancels وعلم يعني, and the other party comes to know within the time period, it is cancelled. وإلا لا. Right? وإلا تم العقد. But if one party cancels, so Sigu Khan declared, Sigu Khan's family said, fear Allah, we have all these payments coming up. So he says, Wallahi, I cancel the sale. And he declares his tawbah, but he doesn't tell me. Once the 3 days are over, what happens to the contract? So he canceled it, but didn't tell me. Yeah, it is. Yeah, it's imda. And to use the expression that Maulana al-Haskafi, Maulana Ibrahim al-Halabi, تم العقد. The aqd is complete. It's considered imda. Why? لأن الشرط علمه. Right? The condition is that the other party know of the cancellation. وإلا تم العقد. تماما. What else completes the contract? ويتم العقد أيضا بموت من له الخيار. So the contract is also completed if the one who has the option to cancel dies. وَكَذَا بِمُضِيِّ الْمُدَّةِ, and likewise if the time passes. So I had the right, I sold this sibha. I got fed up with Sigu Khan's indecisiveness. I sold this sibha for $100 to Ibrahim, but on condition that I have the option to cancel for 3 days. If the 3 days are over, the mudda is over, the option is over, so the ownership then transfers, etc. يتم العقد. وبالأخذ بشفعة بسبب المبيع, and to exercise the right of preemption. Right? The right of preemption is that if a person sells their property, then the neighbor has the right to preempt the sale. That's حق الشفعة. There's a whole chapter on shufa that comes up. But if you exercise the right of shufa, it means that you're satisfied with the ownership. So it completes the contract. And then the general principle, وَبِكُلِّ مَا يَدُلُّ عَلَى الرِّضَى, and with everything that indicates being satisfied with the sale. Right? So this is more general than the previous. This is عطف العام على الخاص. كالركوب, such as riding the animal. لغير, or like such as driving the car around. Same thing. لغير الاختبار, beyond the limits of testing. Right? So what is considered testing? So for example, with the car, right, what would be considered a reasonable test? And that would return to urf. Urf in different places that, okay, you're testing the car, okay. Beyond that, right, it would be considered rida. And one of the signs of testing, going beyond testing, so testing could be that, you take it, you drive it around here and there, but if you start using it, you need, they say one of the signs of كل ما يدل على الرضا أن يتصرف به تصرف الملاك, that you deal with it like the owner would deal with it. So what would be the owner dealing with it? If you own a car, that you start using it for your daily chores. Right? So even within the 3 days, if you ride it to work and then you drive it to work and back, you drive it for shopping, you drive it to friends, you go out for dinner with your family, is that would not be considered testing? Because do the roads differ within your part of the town? No. So nobody would say that's just testing, right? So, and we explained what the khiyar al-shart is for. كالركوب لغير اختبار والوطء, and intercourse, والإعتاق, and to free the slave, وتوابعه, and the related actions like tadbir and kitaba, etc. Okay, so this is what completes the contract. Any act that only owners do. Now, it can be that the buyer does not know about that kind of item, or he's busy. So Sigu Khan kind of like the sibha, but he doesn't know, is this actually kook or not? And he's busy. He has to go to write a series of exams in Toronto. I'll buy the sibha for you for $100 on condition that Sidi Nadir Khan has the option of cancellation for 3 days. Because Sigu Khan thinks that Sidi Nadir knows about sibhas. I don't know if he does. We could ask him. Probably tell a joke or sing a song about it. But ولو شرط, so he tells us regarding this, ولو شرط المشتري الخيار لغيره جاز. If the buyer stipulates the option of cancellation for a third party, it is valid. And this is istihsan. Why? Because it is the buyer, and this is allowed only for the buyer, because the buyer is in need of judgment regarding the item of sale, because the item of sale is the subject of the sale transaction. That's why in English we call it the sale, right? Because it's the item of sale. وَالثَّمَنْ وَسِيلَة. The price is just the means, right? So it's this one. So you can the buyer can specify the option of cancellation for the third party. And the basis is the owner should know what they're selling. Okay? So this is allowed. But in this case, both the buyer, the mushtari, and the third party have the option. So he says, وَأَيَّهُمَا أَجَازَ أَوْ فَسَخَ صَحْ. And whichever of them, the mushtari or the third party, makes imda of the transaction, it is valid. Right? وَإِنْ أَجَازَ وَاحِدْ وَفَسَخَ الْآخَرْ اعتبر السابق. If one says the transaction is complete and the other annuls it, then whichever of the two acted first, then that is what is considered. وَإِنْ كَانَ مَعًا فَالْفَسْخ. And they've acted together, then the fasakh is considered. Why? Because right? Because that is what is entailed by the option of cancellation, right? So, but this is if they were at exactly the same time. The way to solve this is to determine, one person would have likely gone even a moment earlier. ولو باع عبدين بالخيار في أحدهما فإن عينه وفصل ثمن كل صح وإلا فلا. If one buys two abds, two slaves, with the option to cancel with respect to one of them in a sale. This is only valid if he does the following, right? If he specifies which one he has option in and the price of each within the sale is made clear, then this option of cancellation is valid. Otherwise, it's not, because it would lead to dispute. Because if you say, I sell you these two abds for 3,000 and I have the option to cancel one of them, then they would differ. How much is its value? Because they would differ in value and would lead to dispute. And anything that could lead to dispute is considered corrupt. Okay. And then there's khiyar al-ta'yin. Khiyar al-ta'yin, and if someone, again, Imam Abu Hanif, khiyar al-ta'yin is you like several things. So let's say that Zubayr just married Zubaydah. And he went to Istanbul and he didn't know. And he wanted to surprise his wife. She's been talking a lot about really liking the jackets that that muhajjabas are wearing on the street, but he wasn't looking. Zubayr is a pious guy. He's also not sure what colors does Zubaydah exactly like. So he goes shopping. So he finds 3 jackets, and he's actually not even sure of her size. And it's very embarrassing to buy women's clothing if you're a man. I once tried doing it in Ismail Agha. And these 3 ultra-conservative ladies were trying to help me. And they didn't know English much. So there's one saying, is she like me or like her or like her? I'm not going to look. So it's a very embarrassing way of buying. So I just said, look, let me, I said, I didn't answer that question. I just went and just try to figure out what's closest because I got for several members of my family. I was going to ask, are they closer to me or her? And they're all like Ismailaga kind of, you know, ladies who are of the scariest kind of ladies around. Anyways, so you're not sure which one. So khiyaru ta'yin is you take more than one item of sale on condition that you'll be taking one of those. But this is again limited to the extent that it was established textually, by the urf at that time. So they limited to 3 because they said, and the reason that they remained firm on this is the asl, according to Abu Hanifa, is that we don't make exceptions to the bindingness of a contract. The 3 was allowed because, in general, there is good quality, bad quality, and middle. Right? So that's why you would need 3. Here, Maulana Mustafa Zarqa argues in his book Aqdul Bay', which is a very good book, but he has his choices. But he suggests that this khiyaru ta'yin, the option of specification, should also extend to more than 3 if a specified number. So what is the scenario? ويجوز خيار التعيين. The option of specification is valid. وهو بيع أحد شيئين أو ثلاثة. And it is the sale of one of 2 items or 3. على أن يأخذ المشتري أيا شاء. That the buyer can take any that he wants of the 2 or 3. Right? ولا يجوز في أكثر من 3. And it's not valid for more than 3 because the need is fulfilled by that. ويتقيد تخيره بمدة خيار الشرط. And this option of choosing which one you're going to take. So Zubayr took 3 women's jackets. He'll take 1, return the other 2. Or he took 2 and he will keep 1. Or he took 3 and he'll keep 2. Within those bounds. And it's limited to the mudda of khiyar al-shart, according to Imam, 3 days, according to Sahibain, any specified period. So he says, يتقيد بمدة خيار الشرط على الاختلاف. Right? So this is the option of specification. Okay. Now, والمبيع واحد والباقي أمانة. In this case, the item of sale is 1 and the rest are considered amana, a trust in the hands of the buyer. And there's a distinction between this, right? So why is it just an amana here, unlike the when there's a khiyar shart? Because the sale is on 1, the others are not being are they actually being bought? No. So they are as if the buyer gave them with permission. They're not part of the sale. So if it's not part of the sale, it's just an amana. Right? And you can take the ta'lil if you want from Maulana al-Haskafi. فلو قبض الكل فهلك واحد أو تعيب لزم البيع فيه. If one takes all of them, so the buyer takes possession of all of them, and they all are destroyed. So if one is destroyed, or one develops a aib, a defect, then the sale is considered binding in that one because it's no longer refundable. وتعين الباقي للأمانة, and the rest are considered an amana. فإن هلك الكل, if all are destroyed, لزمه نصف ثمن كل أو ثلثه. If all are destroyed, then he has to pay a third of the price of all of them, right? Or half of it, depending on whether the items taken on this optional specification were 2 or 3. And then the optional specification has other details. وَلَيْسَ لَهُ رَدُّ الْكُلِّ. In the optional specification, he can't return all of them. إِلَّا إِنْ ضَمَّ إِلَيْهِ خِيَارُ الشَّرْطِ. Unless he also adds the option of cancellation to the option of specification. تماما. And then there's a discussion. Are options inherited? He says, وَيُورَثُ خِيَارُ التَّعْيِينِ وَالْعِيبِ. The option of specification and the option to an option of canceling due to defect are inherited if the buyer or the one who had the option, if they died. لا الشرط أي لا خيار الشرط والرؤية. But the option of cancellation and the option of inspection are not inherited because they go back to mere choice, and choice is not inherited. But the inheritor has a right to having a non-blemished item of sale. تماما. What if two people bought ولو اشتريا على أنهما بالخيار فرضي أحدهما لا يرد الآخر خلافا لهما. If two people bought one item together, so they're buying jointly, and they said we both have the option of cancellation, what happens? ولو اشتريا على أنهما بالخيار, that both have the option of cancellation. فرضي أحدهما, one accepts the sale. Then خلاص, the sale becomes binding. The second party, because they're buying together, it's, A and, the two buyers are one party of the sale. They're acting together. It's not like I sold the sibha to Zubair and Zubaydah. Zubaydah says, I love the sibha. We're keeping it. Zubaydah said that. Zubair said, I don't want it. But together, they're one transacting party. So if one makes imda, their imda is sufficient. خلافا يعني right, خلافا لهما, right, contrary to the صاحبين. وعلى هذا خيار العيب والرؤية. And the same thing applies in the option of defect. There's a defect. One party says, I don't mind the defect. Right? So if two people bought it, Zubayr and Zubaydah bought the sibha together, but the alif has a big crack in it. Zubaydah sees it, and by the way, there's a crack here, but I don't mind. Zubayr says, I mind. That's between them. It's not my fault. Right? And the same thing with khiyar. If one of them sees it and says, it's fine, we're satisfied with it, the option of inspection is lifted. And then there's the option of what's called khiyarul wasf, right? Khiyarul wasf. And khiyarul wasf is the option of cancellation due to a missing quality, right? This is when a sale is mentioned, made on condition that the item has a particular quality, right? And khiyarul wasf, so this is called khiyarul wasf, right? And this is, but the wasf has to be maqsood. It's a sought after quality. How do we know if it's a sought after quality? Urfan, right? Urfan. So he says that ولو اشترى عبدا على أنه خباز. If someone buys a slave on condition that they are a baker, أو كاتب, or they are a scribe, فظهر بخلافه. Right? Oh, so it becomes apparent that they're not. أخذه بكل ثمن أو ترك. He takes the sale with the full price or leaves it. And the principle is لأن الأوصاف لا يقابلها شيء من الثمن. So the buyer cannot demand a lower price. Can they agree to a lower price? Yes, because that's taradi. They renegotiated the contract. But the buyer cannot force it. You just take it as is or you don't. لأن الأوصاف لا يقابلها شيء من الثمن. Um, that is one component. Also, and similarly, if there's some other wasf that's maqsood that is missing. So, for example, some phones these days, cell phones, some cell phones come with eSIMs and some come with actual SIM cards. And depending on the country you're in, like someone travels internationally, they may want to have an actual physical SIM card. Do you have only eSIMs in Germany, Sidi Khan, or do you actually have physical SIM cards as well?
I'm still using the physical ones.
Okay, so it differs from country, right? But in some places, like, there's certain new phones that have come out that don't have a physical SIM card in them. So if someone bought a phone on condition that this has a physical SIM card in it, because, and depending on your country, the phones come in the same model of phone will come with a physical SIM card slot or not. That's a wasf maqsood adatan. If it's not there, you take it for the price or you refund it. But you cannot just say, khalas, the SIM card slot is missing, so I'm only paying I'm paying $50 less. Because that's not taradi. That's not taradi. Tamaman. So that is what we're covering today. And next, bi'idhnillahi ta'ala, we're going to look at khiyar al-ru'ya. Right? So today, we saw a number of things, right? Khiyar al-shart, its duration, and understand the disagreement between the Imam and the Sahibain. And the fatwa, read the section. Also, this is very critical to understand. We diagrammed it, but try to understand. I gave one or two examples, but if you make a few examples and reason through the steps, the seller has the shart, the buyer has the shart. Try a few sample examples yourself and you'll understand the rulings better, but I can't do it for you. Also, we looked at khiyar al-naqd and khiyar al-ta'yin and the discussion on those. And we also looked at a number of secondary cases, and we looked at a couple of places where the Majalla chose other than, particularly the qawl of the Sahibain when it comes to muddat khiyar al-shart. So that's what we're covering today. And next lesson, we're going to look at the option of inspection, khiyar al-ru'ya. And we ask Allah subhanahu wa ta'ala for ease, assistance, and facilitation. وصلى الله على سيدنا ونبينا وحبيبنا وقرة عيننا محمد وعلى آله وصحبه وسلم وآخر دعوانا أن الحمد لله رب العالمين. Any questions before we close, Sadati?
See,
Hmm.
I apologize. I got a bit confused about the titles or the descriptions. So, was the khiyar al-naqd the one where someone sets condition that if he finds the money within the 3 days, he will
No, if he
pay?
pays, finds the money. No, if he pays with it, naqd a dafa.
That was the one.
Yeah,
Khiyar.
yeah, right?
It's the word khiyar al-naqd and khiyar al-wasf are not mentioned in that, right?
No. Hmm. تماما. And they're very good. The descriptions of these are very useful from the majalla. So if you guys want to divide it up amongst yourself, just gather the key items, key related items of the majalla. You'll find it useful. And see, Abdul Latif, if you remind me, we can include, because I have them in my notes. They weren't inserted into the slides. So just remind me. There's a few critical items of the majalla. We'll share those as well. بإذن الله تعالى. تماما سادتي. But this, the issue of the transfer of ownership, etc., I've explained it, but diagram it yourself and do a few test cases and it'll be much, much clearer. بإذن الله. نعم سيدي. Yes, Sidi Abdul Latif.
There's a question in the chat.
Okay, can you read it?
Besides, when is it decided if the buyer or seller has the option of cancellation?
No, the option of cancellation has to be, the option to cancel has to be specified in the contract. That's why in Arabic it's called khiyar shart. So khiyar in Arabic is the option to cancel. Khiyar shart is the option of cancellation due to its being specified in the contract. So that is the option of cancellation. And there's different ways. One or both parties has the option to cancel, right? It could be because it's specified in the contract. It could be because the buyer has not seen the item yet because of the principle من باع من لم يره من اشترى ما لم يره فله الخيار إذا رآه, right? That whoever buys that which they have not seen has the option of canceling if they haven't seen it. And or it could be because of aib. You don't have to, and we'll look at each of these. And then there's the secondary khiyars. Some have passed by, like the option of specification, the option of non-payment within a specified time. We also looked at khiyarul wasf, the option of canceling due to a specified quality not being present. Like we try to use the example of buying a phone that has a physical SIM card, which a traveler may, because some countries don't use eSIMs yet. Someone who travels extensively around the world, that's a desired quality. And that's different from a aib, because a aib reduces the value according to in the market. But the wasf is just a quality. You wanted it, someone else may not have wanted it. It does not, like it does not diminish the value itself necessarily. Right? Like if someone purchased a abd on condition that they speak Urdu, would that necessarily increase the value of the abd? No, right? Because Sigu Khan, would you actually, if you're smart, you would actually pay more for abd if they know Hanafi fiqh, because they could help you read Indian Hanafi fiqh books. But so that's where it becomes relevant. Now, Sigu Khan.
I was to ask if we're going to say Islamic Law first. Hey,
Yeah, so the option, so the option of cancellation can be specified after, right? Because basically, you can adjust a contract after. So in your case, right? So in the case, for example, you purchase the sibha, or Zubair purchased the sibha for $100, and he remembered Zubaydah. He'd already been in trouble for buying unnecessary things. So he says, I want the option of canceling for 3 days. I said, sure, go ahead, Zubair. So it gets added to the contract. تماما سادتي. So we'll stop there. وصلى الله وسلم وبارك على سيدنا محمد وعلى آله وصحبه